Hello friends, Namaskar. I am Anil Kumar Srivastav. I am present with you with some important section of the Indian Constitution that I shall take up today. And I shall today take up the chapter 16, and which is classified as is the special provision for the certain clauses. Before I begin with, I shall go back in the Indian freedom movement. In 1909, for the first time, the uh, communal part has been introduced, or communal electorate had been introduced in the Marle-Minto reforms, and the Muslims have been given a status of the separate electorate. That is, there shall be a separate seat for them, there shall be a separate electoral list for them, the seats will be reserved for the Muslims, and there shall all the voters in the Muslim reserved seat will be only Muslims, and the other persons belonging to the community, other communities will not be in the electoral list. And in 1919, Indian Council Act, we find, Government of India Act 1919, we find that on the basis of the Montagu-Chelmsford reforms, this has further been broadened, the community or the classes has further been enlarged. For example, in 1909, in Marle-Minto, we find only the Muslim class, and here in 1919, we find the different section named as the Anglo-Indians, the Europeans, the Muslims, and the Jains, the Buddhists, and the Sikhs, and there are further categories on the basis of the payment of the taxes, etc. And it has reached to its maximum in 1932, when the Ramsay MacDonald Award has been declared on the basis of the depressed clauses, because the Britishers thought that the Dr. B.R. Ambedkar is the only leader of the Dalits, and on the basis of this he made a different class, depressed classes, and in 1932 it has been made a MacDonald Award in which these sections have got full expression, and these all things were very minutely discussed and analyzed by the then our leaders like Mahatma Gandhi, Jawaharlal Nehru, and others. They find that this is the policy of divide and rule. They are dividing the communities, they are making the separate list, and they are excluding those persons who does not belong to the that community for which the seats are reserved. For example, if the seat is reserved for the Muslims, then the voter list will only be of the Muslims only, and the other communities belonging to other caste, Brahmin and Hindu and others, will not get their place. They will not have right to vote. Gandhiji was very much opposed of this, and because of his opposition, it was an agreement was reached between Dr. Ambedkar and Gandhi, and by the agreement, the more seats for the Dalits have been made. But the basic idea behind these rules, that the Indians were divided, the communities will be divided, the races will be divided, cannot get momentum because of the farsightedness of our leaders. So when the makers of the Constitution were making the Constitution, they thought that any section of the Indian Constitution should not get a heading like religious heading, or no section will be made on the basis of the religion and caste or race, because if such type of section is introduced, then it will be a continuance of the policy of the divide and rule. That is, there will be a very large gap between the communities, and it will induce a kind of dissatisfaction among the classes and among the communities. So that is why every maker of the constitutions did not name the heading of any chapter or any section that 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 is related with the only basis of the religion, race, caste, sex, or place of birth. So if we go to see the other sections and analyze the different sections, in section 46 we find that there is a section that makes a special provision for the promotion of the educational and economic interest of the weaker section of the people, that the weaker section of the people, particularly SC and ST, there should be a special provision. This section has been made. So if the constitution omits the name of the chapter on the basis of the religion, what would happen if the certain provision for the special classes have not been made? If that is why the certain provision have been made for the certain classes, and it is because of these classes, these provisions, that the communities which have been for less developed become developed, and another idea of division between the communities did not get any mention and did not get any influence in the after the making of the constitution. But the objective of the constitution was the socio-economic and political justice, and this gets in the very provision of the, if we see that Article 14 makes a provision that there shall be no discrimination on the basis of the equally placed persons, that the law will be equal for the equals and law will be unequal for the unequals. That is, if a certain person is living in the plain area and certain person is living in the mountainous area, and because of the production in the plain area is greater than that of the mountainous area, so there are two conditions when the law will be different. That is, if the persons are differently placed, that the persons who are living in the mountainous area are different than that of the different in the sense that the things are less in supply and every good will cost much more because of the transportation cost and because of the production is less there, and that is why they are differently placed, so law will be different for them. And that is, the constitution talks about the differential integrum, that is, there should be a proper differentiation between the two group of persons, the persons who have been taken out of those persons who have been left, and there should be a certain object to achieve it. So these things, intelligible differentia and the object to be received must be reasonable, and on this basis we can make a classification and law will be different. But if we talk about the section 15, which is equal for all the communities, whether they are Hindu, they are Dalits, they are SC, they are ST, all public places will be in the access for all the persons, all the citizens of India. There will be no discrimination. Discrimination is totally banned on the basis of the religion, race, caste, sex and place of birth. That any person can go to the hotel, any person can go to the well, any person go to the all public places, there can be no bar, because the section 15 prohibits all these kind of discriminations. Section 16 also talks about the there shall be no discrimination on the basis of religion, race, caste, sex and place of birth. Section 17 talks about the untouchability, which is prohibited, and this was making the difference between the two communities or the different communities. And if we talk about section 19, it also provides in 1966 that the persons who are very poor, who are belong to the SC, ST, they do not have proper knowledge and proper development. So that is why there should be a special care for their land, that their land only be purchased by the person belonging to the higher communities or developed communities only after the approval of the state authorities. So, and if we go further in 25 and 28, we find that there is a fundamental right of public religion, and that can only be controlled on the basis of the public order, decency and health. And section 29 and 30 makes no provision for on the basis of the religion and caste. So these sections totally say that the makers of our constitution were aware that there should be no provision which should make provision on the basis of the religion, race, caste and sex, because if these enter into our constitution, then there will be differences in the community, and the communities will be dissatisfied, and our integrity will be at danger. And that is why a special provision have been made in the section in the chapter 16, and these special provisions make those who are not in the mainstream of the development, they can also develop, the persons who are 1,000 years behind the persons, those who are developed. And that is why these sections have been introduced. You can also find that in section 325, it has been made that there should be one electoral list for all, whether the seat is reserved for SC and ST, the seat may be reserved for SC, but the voters will belong to the whole constituency, and there will be one common electoral list. So idea of the division has been totally ruled out. And in section 334 you find that the persons who belong to the underprivileged class, or who are not developed, who are poor, who are illiterate, they can also be made equal to those who are developed. And that is why a special provision have been made in Article 34, and Article 34 says that there shall be a 10 years reservation from the commencement of the Constitution for those who are underprivileged, that is the SC and ST will get reservation for the 10 years in different fields, whether it is public, whether in the field of representation in the Lok Sabha or the state assemblies, and that is why this section has been made. And you also find that the section 330 says, in the 330A says that there shall be a representation, a reservation for the SCs, and 330B says there shall be representation for the STs, and section 330C says that there shall be a reservation for the autonomous area of Assam. This has been categorized as separate. Section 51st Amendment Act needs a reservation for the STs in the legislature. 331B and 332(1), that is the state legislature, and in the Lok Sabha reservation. 51st Amendment Act has been introduced. Both the sections have been belong to the 330 and 332, that is the SC and ST reservation will be decided on the basis of the 51st reservation. that is the autonomous area of Assam, will not be covered under this. So, and the next section which provides the reservation, section 57th Amendment Act, which provides reservation for the Arunachal Pradesh, Nagaland, Meghalaya and Mizoram. In these states, if all the seats of the legislative assemblies, or if all the seats of these assemblies are reserved for the STs, then there shall be one seat must be made general seat. So this provision has been introduced, and it has been introduced that the reservation in the Lok Sabha or in the state assemblies will be done on the basis of the population, and this population has been defined, the which census should be used. In 84th Amendment Act, we find that the for 330 and 332 the provision has been made that the 1991 will be the decisive year for the population for the reservation, but in the 87th Amendment Act, it has been again it has been amended that the 1991 was substituted by 2001, that the all parliamentary seats, the delimitation will be done on the basis of the population published in 2001 census, and that is that exists today, and that the territorial constituencies have been done on this basis. So by 84th Amendment Act, we find that the 1991 was used, but census was used, but in 87th Amendment Act, the 2001 has been used, and in 84th Amendment Act, all the seats of the SC and ST have been frozen till 2026 by the 84th Amendment Act. So these are the things that we find in 330. In 330, I have already told you that there shall be a reservation on the basis of the total population of the SC and ST. Suppose SC has 25% population in certain state, then the seats of that state must be reserved for 25% seats in favor of the SC. And suppose the ST has 80% seats in that state, 80% population in that state, then the 80% seats of that state will be reserved for the STs. So this was the provision, and we have further go into the details of the 334. 334 itself says that when it was originally put that there shall be a reservation for the SC and ST in the Lok Sabha and the state assemblies for coming 10 years with the commencement of the constitution, but by the 8th Amendment Act, it was substituted 20 years by the 8th Amendment Act in 1959, because the Parliament found that the people who are backward and who are SC and STs, they are far behind than those who are developed. So there is a need of making them into the mainstream, and that is why the reservation has been extended by 8th Amendment Act in 1959 for 10 years in 334 section. And in 1969, the reservation has again been extended on the same ground in 30 years, that the section 334, it has been put 20 years in place of 20 years, the 30 years has been used. And in 1979, by 45th Amendment Act, we find that still the persons belonging to those communities, NSC, ST, or not developed, and that has not come under the as the developed classes, and that is why it has again been extended, the reservation for SC/STs for 10 more years. And it is also extended for the Anglo-Indian nomination. The section 331 talks about the nomination of the Anglo-Indian communities in the Lok Sabha, that if Lok Sabha is not sufficiently represented by the Anglo-Indian, that the President has got right to nominate 2 persons from the Anglo-Indian communities. And as the amendment was going up, so it was also going up for the Anglo-Indians. In section 333, the governor has got right for the nomination to the Anglo-Indian communities if not represented properly. But in the next Amendment Act, in section 334, the sections Amendment Act 62nd Amendment Act provided for the 10 years revision, 10 more years for the reservation of the SC/ST and Anglo-Indian communities. And it goes on. In 1979, in next Amendment Act, 79th Amendment Act, we find that it is further extended. In 1980, it has further been extended. In the 1989, it has been further extended for 10 years, and in 99, it further been extended for 10 years. In the 104th Amendment Act, it has been introduced as the original head in the section 334, 2 subsections, certain provision, and under the certain provision, the 2 subclauses have been introduced. One subclause was A. In this, it was provided that the SC and ST reservation for the 10 more years will go ahead in 2019, but section B, it was said that the 70 years was substituted by 70 years, that there shall be no reservation for the Anglo-Indian, no nomination in the Lok Sabha or the Rajya Sabha. It was found that the Anglo-Indians are properly developed and they have proper representation in the Lok Sabha and the state assemblies. There is no need of nomination or reservation, and that is why the section 331, which says that there should be a nomination in the Lok Sabha for the people belonging to the Anglo-Indian community, if they are not represented, have become obsolete, and it has lost its significance, and section 333 has also lost its significance by the 104th Amendment Act. And by 2020, there is no representation, there is no reservation or nomination of the Anglo-Indian community, but it is continuing for the SC and STs. If we find that there are certain other sections in this chapter which provides for the development of the socially for the SC and STs. Suppose these sections have got the some color of the class or religion, then our people will be divided. People will feel some kind of hatred between them, and that is why the name of the chapter was written as certain provisions for the certain classes which were backward, and many main provisions from 330 to 350 has been made. For 347 to 350b, the provision have been made for the development of the linguistic minorities, that is their script must be saved, their numbers must be saved, and all the cultural rights must be saved to belong to the linguistic minorities. And section 341 talks about the SC community, and 342 talks about the ST communities. In nowhere thus there is a definition of the SC and ST in the section which communities will be added and which communities will not be added. It depends on the, there should be a discussion on this topic, that which communities should be included in the SC list or ST list from the each state. The president has to discuss with the states, and the ultimate power lies to the parliament, and if the parliament gets that mandate, only then it is done. You have just heard the Manipur rights. The Manipur rights has been a very dangerous thing for us, because still the violence is being done. It is because the one of the communities, that is called Mathai, wanted to make them state scheduled tribes, and that is why the hatred between the two communities, Naga, Kuki and the Mathis, has started. And so it is here that we should develop a mechanism to sort out these things, so that no violence is done in future, and every community live with the friendship and with the respect to each other. And so these sections make us to tell. There is a section 164 which talks about there should be a minister, tribal minister, in the states of Odisha, Chandigarh, MP and Jharkhand, because there are the many higher number of the STs, and that is why it has been made. So we find that our makers of the constitution were very conscious of the differences about the communities, because they fought the freedom movement, and at different time and different places they felt that the integrity of India can only be maintained if we do not make any provision, any article in the constitution on the basis of the religion, on the basis of the caste, on the basis of the community. If any section is made on the basis of the community and caste, then the whole society will be divided. And that is why they have chosen, they have first of all prohibited any kind of treatment on the basis of the caste, religion, race, caste. But the second aspect they wanted to cover, and that is to say that they felt that there is a society, there is a community that is called SC, ST and backward classes, which time memorial have remained out of the mainstream, and because of the putting them into mainstream of the development, the certain provisions have been made, which I shall discuss later on some articles regarding chapter 16. So we should pray, and we should be highly obliged to our forefathers who made the constitution, and they kept both the things at the same time. On the one side, they did not make any mention of the in the heading of the class as on the basis of the religion, race, caste, sex, and on the other hand, they knew that some classes are backward, are since time memorial, and that is why they make a special provision for the certain classes, that is also known as section 16, chapter 16. So we come to the end of this discussion, and I think that you might have learned this section 330 and 332, and the other sections I will be discussing in the coming classes. That's all for today. Thank you.